Hi, I'm Ken Mann with Equity Partners HG. With me today is Lisa Epps from the law firm Spencer Fane in Kansas City. Lisa is a partner at the firm and works in their finance practice as well as in bankruptcy and restructurings. Today we're going to talk a little bit about when a plan of reorganization might be a more appropriate tool than a 363 sale to accomplish a sale of a business. So I guess, Lisa, I'll start with the question of just in general, what are the issues, or when do you think a plan makes more sense?
Well, I think that if you would have asked that question prior to the Supreme Court deciding Jevic, my answer probably would have been a little bit different than it is now. I think that there were a variety of different issues in Jevic, but the one most applicable to bankruptcy sales will be once a 363 sale is completed, is a structured dismissal available? Basically, is there an easy way out? And under certain circumstances, I think the Supreme Court said that no, a structured dismissal isn't available after a 363 sale. And so you're looking at either a confirmed plan, a conversion to Chapter 7, or a dismissal of the case.
Okay. So if a sale is of substantially all the assets, and let's say that the only party getting paid is the secured creditor, has anything really changed? Because there wouldn't be a likely plan there anyway. It would have been a conversion to a Chapter 7. Is that right?
If they buy substantially all of the assets, typically there are causes of action, D&O claims, perhaps some liquid assets like that could be put into a liquidating trust, and you could get a plan of liquidation confirmed. But you're right, you're not reorganizing a company like we typically think of a plan doing. It's a situation where whatever assets are left after the sale is approved by the court are put into a trust or another vehicle like that.
A common benefit that I hear in selling businesses to using a plan would be the avoidance of paying transfer taxes as you would pay in an asset sale. Is that a good enough reason to go the path of a plan, or maybe that depends on the size of the case?
Well, I think that you can get a sale order which deals with the transfer tax issue. However, under the bankruptcy code, that can't take effect until a plan is confirmed. So you can still get it in your 363 sale order. You just have to wait until you get a plan confirmed for it to be put into effect.
Okay, and in that example, that would be a liquidating plan. You've sold substantially all the assets.
Right.
How about some of the cons of going the path of a plan versus a quick 363 sale?
Well, I think we're seeing a lot of changes in the landscape. I think that when General Motors was filed and cases kind of in the late 2000s, the debtors rushed to court hand in hand, usually with their secured lender, saying, if we don't sell the business within 30 days, then it's going to shut down. I mean, you've heard this because that's exactly why you're called in. And so I think in the beginning, judges, and because parties didn't object necessarily, people weren't asking that many questions. And I think now the tide is turning where people are asking questions and the judge is saying, is this really a melting ice cube? Are you telling me that if I don't approve something that nobody has had an opportunity to review, if I don't approve it today, then the business is going to shut down? And I think that more often than not, the business can, and I say this as a Chapter 11 debtor's attorney, but I think a lot of times businesses can last a little bit longer than sometimes we say on the first day.
Would you agree there are those cases where if you were to take the 60, 90 days to go through voting and a disclosure statement and all of those things, there wouldn't be anything left to sell, particularly in the smaller cases?
Oh, I think so. And I think that, yeah, I mean, it's time consuming, the financial burdens, all of the information that's required to go in a plan and disclosure statement, very well, a company might not be able to make it through that process. But if you do a sale and then after the sale work on your plan of liquidation, then that might be the most efficient route to go for a company.
Now, if you were representing a secured creditor in a case, does your view change about plan versus 363?
Well, I think a lot of it will depend on where you can file. And so, that's when, based on, that's when you want to hire really good lawyers who understand the courts, understand the judges, understand what jurisdiction you're in. So I think, as a secured lender, as a creditor, you want to know, what judge you might draw, what court you might be in, and, that will drive it because, a judge on the Missouri side may do something very different than a judge on the Kansas side.
Yeah, local knowledge is critical. Make sure you're hiring good counsel that knows what they're up against in that particular court.
Well, yeah, because I think that if, whatever constituency you are, if you represent the debtor, if you represent the bank, that there may be certain things that you want, and you may be able to get those in some courts in front of some judges, and you may not be able to get those in front of others. And that's almost as important as, those practical issues are almost as important as the legal issues.
So I've always viewed 363 as the most efficient tool to sell a business as a going concern in a Chapter 11, and that really plans of reorganization were only appropriate for businesses that were going to truly reorganize, not sell. Is that how you feel, and has that changed because of Jevic?
Especially now, you don't see a lot of companies that file that can truly reorganize, and unless they're able to get the agreement of all of the constituencies, because under the bankruptcy code, in order for ownership to retain its ownership after a plan is confirmed, all of the creditors have to be paid in full with interest over time. And a lot of the reasons that a company will file for bankruptcy is to shed itself of debt and obligations. So it makes it tougher.
Okay. Anything else?
Well, I do want to put in a good word and pitch for my good friends at Equity Partners, Ken Mann and Fred Cross. We had the opportunity to work with them, it's been several years ago now, and we represented a secured lender in a bankruptcy case, and they came in and were hired by the debtor to manage the sale process. And there was a time when we weren't sure who was going to bid on this asset, bid on this company, but Ken and Fred repeatedly assured us that they would bring people to the table beyond the stalking horse. And on the day of the auction, there were two parties that just kept bidding up the price, and it was the most amazing thing. The client and I sat there in the courtroom in absolute awe that this was happening. And at the end, Ken and Fred said, for a good auction, all you need are two interested bidders. And I have used that phrase a lot in cases. And so it's been fun to get to know you guys over the years, and we love the opportunity to work with you.
Oh, thank you very much. It was a good story, and appreciate your insights on a plan versus 363. Thank you very much.
Thank you.